Vistage member and your moderator today. Title of our presentation today is A Business Owner's Guide to Asset Protection and Succession Planning, and our presenter is Hillel Presser, who is an MBA, author, attorney, president of the Presser Law Firm, has featured in major publications and written the 3 books you see on your screen now. Here's something you love about Hillel. He's a Vistage speaker, so if you like what you hear today, tell your chair and he would be happy to speak to your group. Hillel Presser, please take it away.
Thank you so much for the kind introduction, and hopefully I can live up to those kind words. Today we're going to talk about both asset protection and business succession planning for the business owner. You know, first I want to talk about what asset protection is. And my legal definition of asset protection is that asset protection is the legal process of how to title one's both personal and business assets to put them beyond the reach of future potential threats and creditors. And what we do as asset protection attorneys is we help our clients protect any asset they have from any financial threat. So you work very hard for what you have, and what we want to do is we want to make it so difficult, so expensive, if not impossible, for anybody to collect against you that they don't want to sue you in the first place. You don't want to be the low-hanging fruit. You know, you don't want to be retired and you're backing out of your driveway and you hit a bicyclist and you lose it all. You don't want to be retired, you save up, you buy 5 or 10 rental properties, someone slips and falls and you lose everything and you have to start over from scratch. So a lot of people say, well, isn't that only for the ultra wealthy? And the answer is no. In fact, the less you have, the more important the protection becomes. I always take an example. We represent a lot of professional athletes, NFL, NBA guys, and take one of my football players that signs a deal for $50 million. Well, if he gets sued for $5 million, he's not happy, but he still has $45 million left. Contrast that with the average person who saved up a couple $100,000 over their career. You know, if they get sued for a few $100,000, if they get sued for $1 million, it could be catastrophic. And a lot of people say, well, what if I already have an asset protection plan? And if you do, it's fantastic. But understand that every year the laws change, every year your assets change, and probably one of the biggest misconceptions I see are trusts. So many times people walk into my office with a revocable or living trust thinking they're protected, when in fact it's a great estate planning tool when you die, but does absolutely nothing to you from an asset protection point of view. So why do you need asset protection? I showed this cute little cartoon. It's 2 lawyers talking. One says, I say sue. The other one says, anyone in particular. I always get some smiles when I show this, but this is the reality, guys. You know, just like you're smart enough to get together with Vistage and help each other, the lawyers are getting together and they're trying to figure out who their next target is. There's over 100 million lawsuits every single year, and that number is only growing. Lawsuits have literally become the next biggest business. They say that you get rich these days in 2 ways, lottery or lawsuit. There's a 1 in 4 chance you will be sued in the next 12 months, and the average person and business is sued 5 times over their lifetime. Now, when I say this, you know, sometimes people say 5 times, I got sued 5 times this month. And other times they say 5 times, I've never been sued. These are just the nationwide stats. There's a 50% chance of divorce. When I give this speech in Florida, where I'm talking to you from today, I say there's a 99.9% chance of divorce. Don't tell my wife. And a lawsuit can cost you tens of thousands of dollars even if you win the case. You know, if somebody looks at me wrong, I can sue them for intentional infliction of emotional distress for $10 million. I can't work anymore. I can find a lawyer on any corner that'll take the case for free on a contingency fee basis. It costs me nothing but 20 or 30 minutes of my time, and it might be tax-free money if I win. Meanwhile, if you need to defend yourself, it's probably going to stay in court for 3, 4, 5, 6 years and cost you hundreds of thousands of dollars. So unfortunately in the U.S., and it's not like this in every country, they make it so easy to sue anybody you want for free, but so difficult and expensive to defend yourself. So the trick is not making money, it's keeping it. And the challenge I give to every Vistage member is for every 60 minutes you spend making money, stop and spend 60 seconds thinking about how to protect it. You don't want to have to start all over. So a lot of people say, well, isn't that what insurance is for? And I love insurance. I tell my clients to buy as much as they can. It's cheap and it helps you sleep at night. But insurance is not the answer. That's because insurance companies are some of the most profitable companies. And that's because the majority of lawsuits aren't covered by insurance. Anybody who's actually read their insurance policy knows there's about a page of what's covered and about 50 pages of exclusions. My dad used to tell me growing up, the big print giveth, the small print taketh away. Your insurance company might pay, but your coverage may be inadequate. If you have $300,000 in coverage, but you get sued for $1 million, you've got to come out of pocket the rest. Your insurance company might go bankrupt. If I would have said that 5 or 10 years ago, you'd kick me out of here. Today we have banks and Fortune 500 companies going out of business. Who's to say the insurance companies won't be next? And there's a ton of things that insurance doesn't cover. They don't cover other uninsured financial risks, divorce, etc. The golf cart, it's excluded from the homeowner's policy. It's excluded from the car policy. So insurance is great, but alone it's not the answer. You want to have your own asset protection plan to supplement your insurance. I call it belt and suspenders approach. So there's 4 basic strategies when it comes to asset protection. In the middle, we have exposed wealth. Exposed wealth is anything that's in your personal name. So if you have checking, savings, stocks, bonds, CDs, money markets, brokerage accounts, any liquid assets in your name, you can lose them. If you have real estate in your name, you can lose them. If you have shares in corporations or membership interest in LLC in your name, you can lose them. If somebody owes you money, you can lose it. Anything that's in your personal name is exposed. So the whole key to asset protection is you don't want to own anything. The whole key with asset protection is to own nothing but control everything. Own nothing but control everything. And I know it's crazy because your whole life you're taught acquire, 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 and now some guy's telling you to own nothing. You guys do whatever you want, but this is not my subjective opinion. This is an objective fact. Any assets that are in your personal name are exposed, and you can lose them. So I'm not here to give you problems. I want to give you solutions. So let's talk about a few ways that you can protect those assets. Number 1 is probably my favorite. It's to transfer the asset into a protective entity. And there's tons of different types of protective entities, LLCs, limited partnerships, S-corps, C-corps, trusts. They go on and on. And to me, it's a really cool thing because, I have a social security number, you have a social security number. If I get sued, they can't come after you. If you get sued, they can't come after me. We are different living individuals. Well, no difference with your protective entity. You have the social security number. Your protective entity has a tax ID number. So if you have a brokerage account in your name with $500,000 and you get sued, you can lose the $500,000. But if you have a brokerage account in a protective entity like a limited partnership, you can't lose any money. If you have a piece of real estate in your name and you get sued, you can lose it. But if you have a piece of real estate in your protective entity like an LLC, nobody can take the real estate. So one really nice and neat strategy is to get the asset out of your name where it's exposed and unprotected and put it into the name of some sort of protective entity. Another strategy is to protect with liens. And I tell the joke that poverty is power. It is cool to be poor. I mean, what do you think a lawyer does before he sues you? He looks you up. He wants to know what you have and if you're a good candidate for a lawsuit. So there's all sorts of ways to put enforceable liens and mortgages and encumbrances on your assets. For example, you ever loan any money to your business for machinery, equipment, marketing, employees? Of course, everybody does. Well, if you loan $200,000 to your business on a Monday, you better make sure that on Tuesday you publicly record a lien, a mortgage, an encumbrance, a UCC that's public to the world, showing them that you're the first creditor in line. That way, God forbid anything happens with the business, at least you get paid. You're working the hardest, the most. Why shouldn't you be compensated? No different with real estate. You know, if you have a property that's paid off, maybe think about getting a mortgage. Maybe think about getting a line of credit. If you get a line of credit, you won't have to pay for it unless you pull from the line of credit. but when a lawyer goes to search you, it'll show that you have a mortgage on the property. So there's all these different ways where you can equity strip any asset, whether it's shares in a corporation, real estate, membership interest in an LLC, the business itself. But there's a lot of ways to protect with liens to make your property valueless. The next strategy is to convert into exempt assets, and this is pretty neat. Every state has a different list of exemptions. And if you want to look at the exemptions for your state, you can go to our website. It's www.assetprotectionattorneys.com. That's www.assetprotectionattorneys.com. And we list the exemptions for every single state. And what exemptions are just certain assets that are protected by state law. So for example, in Florida, they protect your house, while in North Carolina, your house might only be protected anywhere up to about $70,000. In Florida, they protect your retirement accounts, your life insurance, your annuities, where in Georgia, your life insurance might be only protected up to about $4,000. So every state has a different list of exemptions of assets that either are or are not protected by state law. And these are really neat because if you find out what assets are protected by state law in your state, you can be worth $5 million or $500 million, and as long as all of your money are in those exempt assets, nobody can take what you have. And lastly, the last strategy is to transfer all ownership rights. Probably the biggest thing we see, and we're going to talk about this a little bit later today, are when people own shares of corporations. That is a huge asset. And I'm going to save it only because we have a whole slide on it. But what you want to think from a very general overview picture is you don't want to have shares in a corporation owned by you. You don't want to have membership interest in an LLC owned by you. Because if you get sued, a creditor can go after them. You want to have those owned by some sort of protective asset protection entity, and we'll talk about that in a little bit today. So probably one of the biggest misconceptions I see with business owners are corporations. So I always ask people first, why did you set up a corporation in the first place? Well, the reason why you set up the corporation in the first place is obviously you want that corporate protection. You want to make sure that, God forbid, if someone gets injured or something happens with the business, they only come after the business and they don't come after you. So for example, you open up Jim's Car Wash. If you open it up in your name and somebody gets injured, they sue you. You can lose everything you own. But if you open up Jim's Car Wash and Jim's Car Wash, Inc., well, if somebody gets injured at the car wash, they can only sue Jim's Car Wash, Inc. They can't sue you. So corporations are really good to protect your personal assets from business debts and liabilities. Here's the problem. Nobody ever thinks about it the other way around, and when I speak to business owners from Vistage, they always tell me when I ask them what their biggest asset is, they always say their business, because the business is the nucleus. That's what pays them. That's what pays their credit cards, their family vacations, their kids' tuition. And what people don't realize is that if you own shares in an S Corp, if you own shares in a C Corp, well, if you get sued, somebody can take those shares. So if you get sued for $100,000 and you have $100,000 in the bank, someone could take the $100,000. If you get sued for $100,000 and you have a boat that's worth $100,000, someone could take the boat. If you get sued for $100,000 and you have $100,000 in publicly traded stock like Google or Apple or Facebook, somebody can take that Google or Apple or Facebook stock. No different with your private company. If you own shares in the S Corp or the C Corp, a creditor can take them. And if you own more than 50%, now a creditor can vote. They can hire, fire, liquidate the company, bankrupt the company, do anything and everything they want. And I've seen businesses that have been around for 20, 30, 40, 50 plus years that were very, very successful, but they go out of business, not because of anything with the business, but the primary owner of the shares gets sued. Maybe it's a divorce, a car accident, a breach of contract claim, a short sale or foreclosure deficiency, whatever it may be. So if you own shares in a corporation, you can literally lose your entire business. Now again, we're not here for problems, we're here for solutions. So there's a lot of different individualized and customized and tailored ways to protect your business, but maybe 2 or 3 of them real quickly. Number one is get those shares out of your name. If you own shares in a C Corp, take the shares out of your name where they're unprotected and transfer them to a protective entity, maybe like a limited partnership where no one can touch them. If you have shares in an S Corp where they're unprotected, maybe transfer the shares out of your name where they're unprotected into the name of an LLC where they are protected. Another thing you can do is called a conversion. You can actually convert your S Corp from an S Corp to an LLC taxed as an S Corp. And it's pretty cool because the way an S Corp is treated in most states is different than the way an LLC is treated in most states. In most states, if you own an S Corp, somebody can take your shares and take over your business. In most states, if you own an LLC, somebody cannot take over your membership interest in the LLC. So an LLC is a much better planning choice than an S Corp. So if you're currently operating out of an S Corp and you chose that for tax purposes, the S Corp tax status, you can do a conversion where you tell the state, I want to change from an S Corp to an LLC taxed as an S Corp. Now you got the best of both worlds. You have the same great S tax status, and you have the great asset protection laws from the LLC. It's not a new company, it's the same company. It's not a new tax ID, it's the same tax ID. It's not a new bank account, it's the same bank account. It's not a taxable event. Now you're just an LLC versus an Inc., but you still have the S status. And this brings me up to one other point. You got to make sure your team talks. What good is it if your financial advisor makes you money if you pay more in taxes? What good is it if you pay less in taxes but you lose everything to a lawsuit? What good is it if you protect everything from a lawsuit, but when you die, half of it goes to the government in estate tax? You got to make sure your team's talking. It's one of the biggest problems I see with my clients. Nobody's financial team talks. And if you would have a 2-minute conversation with your team before you set up your business, you wouldn't have the S Corp or the C Corp that you own. You'd have the S Corp or the C Corp owned by some sort of protective entity, or you'd have the LLC taxed as an S. And there's so many things that we'll talk about, not just today, but it's not that I have all the answers or I'm the smartest guy. It's simply that your team is not talking. So a really big takeaway is you got to get your whole financial team on board. Appoint one of them the financial quarterback and make sure that everybody's on the same page. It can literally save you millions or tens of millions over your lifetime. Now, whenever we have different companies, we always want to have different LLCs. No matter how small the business is, you have an LLC, and you got to have separate LLCs for each division. That means one LLC is not enough. If you're a builder and you do architect and design, that's 3 companies. One LLC for the building, one for the architect, one for the design. If somebody gets injured on the building part of the business, why should they go after the architect and design portion? If you're a manufacturer and you sell products wholesale, retail, online, that's 4 companies. One to hold all the inventory, one to sell wholesale, one to sell retail, and one to sell online. If a product injures someone in the retail store, why should it affect your wholesale and online and inventory? So different divisions, different locations, different LLCs. I had a guy, he had 14 fast food franchises in one LLC. Well, someone got sick at one and it affected all 14, where by putting his eggs in different baskets and separating his company by division and location, he literally could have saved the other 13 companies. And it's not just for asset protection. I mean, think about it. By putting your company into different LLCs and different divisions and different locations, you're going to get much better financial data. What divisions stand on their own? What locations stand on their own? Which ones do you want to keep open? Which ones do you want to close? It's also going to allow you to sell all or part of your business. If you saw the movie Pretty Woman, the guy would buy businesses, he would chop them up and sell them in pieces because they're worth more in pieces. Today, you can either sell your business or you can't sell your business. But if you separate your business into different divisions and different locations, well, then you can sell parts or all of your business. Maybe you're the builder and you don't want to build anymore. Sell the building division, but keep the architect and design division. Maybe you're the manufacturer and you don't want to hit the pavement anymore doing the wholesale, online, and retail. Well, sell those 3 divisions and keep the manufacturing. Also on top of selling part or all of your company, it gives you the ability to attract key talent and keep key employees. Today you have a really tough decision. It's either give people part of your business or don't give them part of your business. But by separating your business into different divisions and locations, now you can attract key talent. You can keep great employees by giving them part of the division they're good at. If you have a great online marketer, give them part of the online division. Don't give them part of your whole company. So by separating your company into different LLCs for divisions and locations, it not only gives you the asset protection, but it gives you better financial data, the ability to sell part or all of your company, and it also allows you to keep key employees and attract talent by giving away some ownership, but not the entire thing. It's also not good enough to essentially just break your company up into different divisions and locations. And what I mean by that is you also want to break up your company by assets. So, for example, when I have a business owner and they have an operating company, if they only have one operating company, they're in big trouble because when, not if they get sued, the creditor will go after everything in the operating company. The machinery, the equipment, the cash, the accounts receivables, the intellectual property, domains, trademarks, phone numbers. You can lose everything. Your operating company should own absolutely nothing. If you have $1 million in machinery, well, you should have an LLC for the machinery, and you should lease it back to your company. If you have intellectual property, I was speaking to a client earlier this morning, a Vistage member, he had about $1.5 million in intellectual property. It shouldn't be in the operating company where you can lose it. It should be in a separate LLC, and it should be leased back to the company. So you want to think what assets are within your company and think about stripping them out, protecting them, and then leasing them back to the business. But you never want to keep them in the operating company because when the operating company gets sued, you'll lose all of those assets and you won't be able to operate. So I want to talk about business succession planning. What I want to do is I just kind of want to go through a little bit of the criteria, and then I want to just give you some examples. Essentially, a business succession plan is a method by which a person creates a plan to disperse or transfer business assets from him or herself to another party at the time of their retirement, incapacitation, or death. Essentially, business succession planning is estate planning, but for your business. And this has been the hottest topic with Vistage groups. I speak all across the country to the different Vistage groups. In the last 6 to 12 months, this has been the biggest thing. And it's crazy how many successful business owners out there don't have a business succession plan. And there's a lot of benefits to the business succession plan. You want to maximize the value of your business. You want to ensure that all of your key employees will keep their job. You want to create uninterrupted transition of your business. And of course, you want to incorporate your tax, estate planning, and asset protection goals. And we're going to talk about all this in greater detail. And when you're doing your business succession plan, you got to make sure that you have the right documents. This goes not just for business succession planning, but this also goes for, asset protection planning. The devil's in the detail. Anybody can set up an LLC. Anybody can set up a limited partnership. What matters is what's in that customized and individualized and tailored agreement. Do you have all the asset protection clauses, all the anti-creditor clauses, all the business succession planning clauses? And I just want to talk a little bit more about business succession planning. Essentially, there's a couple different situations that you can run into. Number one is if you have a partner. Let's say you have a 50-50 partner. And it doesn't matter if it's 50-50, 60-40, 70-30. If you have any partner, you need a business succession plan. You need to know what is the value of the business, what is going to happen if someone passes away, gets injured, retires, becomes incapacitated. How is the person who's supposed to buy out their interest going to have money? Are they saving each month? Are they taking out a life insurance policy on someone? Et cetera, et cetera, et cetera. Because if you don't, what happens is one partner dies, and then a week or two later, the other partner goes, to the dead partner's spouse, and he tries to give them a check for the business. So let's say they try and give them a $500,000 check for 50% of the business. Well, essentially, that widow was going to say that's not enough. It's not worth $500,000. It's worth $5 million. And now both parties, the estate and the remaining partner, are going to go hire lawyers. They'll probably spend $1 million over the next 7 years, and they're going to sue each other. Meanwhile, the business is going down the drain. So if you have a partner, you need to know what your business succession plan is. And it's not good enough to do it once. I make my clients do it once, and I make them sign off on it every year and get a new valuation every year. Because if you have a valuation of your business in 2015 and someone dies in 2019, well, what's it really worth? Then we get the clients who don't have partners. This is for the people that own 100% of their business. Well, you still need to have a business succession plan. If you own 100% of the business and you don't have a business succession plan, well, when you pass away, your estate, your wife, your husband, your kids, they get nothing. All of your hard work is down the drain. But if you have a business succession plan, they get value. And without it, they may or may not try and sell your business 6 months later after they're done grieving. But more than likely, they'll get nothing or they'll get pennies on the dollar. So if you own 100% of the company, you want to investigate what's your business succession plan going to be. Maybe you want to sell to a key employee or key employees. Maybe you want to sell to a competitor. Do you have somebody who can come in and take over the business and have the cash flow go to your estate? Again, it's all individualized and customized and tailored planning, and there's so many different options, but you got to have an option. And lastly, I talk to those people who own 100% of their business, and they say, well, I don't have any partners, and I don't have a family. I don't have a wife or husband, or I don't have kids, or you know what? I'm just not concerned with them getting value. Well, you still need a business succession plan. If you don't have a business succession plan and essentially you pass away on a Monday, well, on Tuesday, okay, you have 100 employees or 50 employees or 5,000 employees, okay, that are out of a job. So it is so important that, you have a business succession plan. Now, I just really wanted to give you a very, very brief overview today of asset protection, what it is, why it's so important, why liability insurance is great, but why it's simply not enough. I also wanted just to give you a really, really brief introduction today of some strategies that you can do, how everything in your personal name is totally unprotected, and some things you can do to protect it, or to transfer it to a protective entity, protect with liens, convert them into exempt assets and transfer the ownership rights. I think it was really important to talk about the corporations because it's one of the biggest mistakes I see Vistage members do. They own the S Corp shares, they own the C Corp shares. You got to get those shares out of your name where they're unprotected, or maybe do a conversion into an LLC. I think it's really important that you get your team talking. That way, everybody's on the same page. When it comes to businesses, you got to separate them into different divisions and locations, not just for the asset protection, but also, because it'll give you better financial data, the ability to sell part or all of your company, and give you the ability to keep key employees and attract talent by giving them some ownership but not all. And I also think business succession planning is really, really important. You got to make sure that you have a plan for your business, just like an estate plan for you when you die, just like an asset protection plan for you to keep what you have while you're alive. It's so important. What I want to do now is I just want to end on a light note, and I'd urge you to stay on because we're going to have some really good questions and answers that I think will apply to a lot of people. But I'd just like to end on a light, funny note. So what I put together for you are the 10 craziest lawsuits that I've seen. And these are all real lawsuits. Number one, a couple sued an airline over a cockroach sighting. The couple stated that seeing cockroaches crawling out of air vents caused them great distress and forced them to throw away their luggage in fear of cockroach contamination. This was not United Airlines. Next, a Michigan woman sued a movie studio for not accurately portraying a movie in the trailers. I love this one. A fugitive sued his hostages for not helping him escape. He claimed that they promised to help him escape, and when they didn't, they breached an oral contract. A woman obtained walking directions, walked in the middle of the road, and got hit by a car. She sued for bad directions. An employee sued for wrongful termination because the employee actually helped customers instead of taking a break. I love this one. Wedding couple sued a photographer for photos that didn't come out right. $4,000 is a refund, $48,000 to restage the entire wedding. And it's actually funny. I gave this speech to a Vistage group a while ago, and the chair jumped out of his seat. He said when he got out of college, he filmed weddings, and this happened to him, and he got sued for this very same reason. Customer sued for being overcharged for sausage by 2 cents and won. Anyone who has kids out there, watch out. 2 children sued their mom for not spoiling them. They claimed that she was a bad mom by requesting them to be home by midnight, haggling over dress budgets, and failing to send them college care packages. They sued the mom for $50,000. A woman sued a police department for allegedly making her listen to Rush Limbaugh's radio show while she was handcuffed in the officer's car during the arrest. And lastly, a man divorced his wife, sued, and he won $120,000 when his wife had an ugly baby. She claimed she was naturally beautiful. She had a half a dozen plastic surgeries. It was fraud. I would hate to grow up as that kid. So again, I know it was short and sweet. We tried to keep it to 30 or 40 minutes today, but I'd urge you to stay on because now we're just going to spend a few minutes, taking some questions and answers. And I think that they'll be very, very important for you because you may or may not have the same ones. I truly hope today was timely, educational, and valuable. And now I'm going to turn it over for Q&A.
Thanks very much, Hillel. Great job. Can we get in on a class action suit for that Rush Limbaugh suit?
It's funny. Sometimes I wonder, is that a frivolous suit or is that real?
We do have several questions, so let's get started with those. First of all, one great question here is how do my retirement accounts fit within my asset protection plan?
Good question. So retirement accounts could be protected under your state law exemptions. Every state is different. So what I would urge you to do is go to the website. It's on the screen, www.assetprotectionattorneys.com. You'll see a button, and it's called Financial Planning Exemptions. And we'll list every single state, Florida, New York, California. If you click on your state or where your parents or where your kids live, you'll see if your retirement accounts are protected in your state and to what extent. So a lot of times there's nothing you need to do to protect retirement accounts because in a lot of states, like for example, Florida, North Carolina, etc., they are protected, but it's all done on a state-by-state basis.
Great to know. Next question is, when should I start to consider business succession planning?
Sure. So it's never too early to start. I always tell my clients that whatever you do is not set in stone. Maybe you have a business succession plan where you decide to sell to a key employee today. Well, it doesn't matter if you change your mind 5 years from now. It's probably not going to be an irrevocable event. So it can never hurt to start as early as possible because anything you do is better than nothing, no matter what small steps you take. If you look at the experts, and we have a business succession planning specialist, attorney within our office, I handle more of the asset protection stuff. But what the stats say is that if you're really looking for a time frame, they suggest that you should do it 7 years before you exit the business. So that would be 7 years before retirement, 7 years before death, not that you know that. But look, it can never hurt to get started as early as possible, and you can always change it.
Great input. Here's one. I'm not really clear about the direction, but maybe you will be. The question is, what about dividends at the end of the year? I assume that they're referring to transferring S-Corp shares, for instance, to an LLC or something along those lines.
Well, if you have dividends, more than likely it's either going to come in the form of, let's call it cash, liquid assets, or it's going to come in the form of maybe potential stocks, warrants, things of that nature. So if it comes in liquid assets, if you're talking about like distributions, profits, salaries, dividends from a liquid asset standpoint, you don't want to keep it in your name because you can lose every penny. You want to transfer those liquid assets, whether it's checking, savings, stocks, bonds, CDs, money markets, brokerage accounts, to a protective entity. And there's lots of different types of protective entities, but a really good one inside the United States is a limited partnership. There's also a lot of international entities as well. If from a dividend perspective standpoint, they mean they might get more ownership in the business, you then want to do the same thing. You never want to own the shares of your S Corp. You never want to own the shares of your C Corp. You never want to own the membership interest in your LLC. So no matter if you have 1% or 50% or 100%, you always want to transfer any of that percentage out of your name where it's unprotected into some sort of protective entity where it is protected. So you might transfer the LLC interest or the C Corp shares out of your name where they're unprotected into a limited partnership. And again, it doesn't have to be a limited partnership. There's other types of entities out there. That just happens to be one of the best ones. You might transfer the ownership interest in an S Corp to an LLC holding company. So again, there's no one size fits all. It's not cookie cutter. It's individualized and customized and tailored. But the theory is get it out of your name where it's exposed and into a protective entity where no one can touch it.
Thank you very much. Here's one that I think it's common enough that it bears repeating. If my business is held in my living trust, are the assets protected from being sued? Great
question. The answer is absolutely not. This is by far the biggest mistake I see with business owners. They go to an estate planning attorney, they title everything to their trust. Well, everything they just did was wrong, because what they did was great for estate planning. When they die, they'll avoid probate. Their assets will go where they want them to go, quickly, privately, and hopefully with less taxes and attorney's fees. But it's totally exposed. Any asset that's in your living trust, your revocable trust, is totally exposed. There's 0% asset protection. You're 100% unprotected. So the biggest mistake I see is people titling their assets to their revocable living trust. Again, it's great for estate planning, but it's terrible for asset protection planning. The correct way to do it is to make sure your team talks. That way your estate planning attorney is talking to your asset protection attorney, and is a very, very simple way to do it. All you do is you title all of your assets to an asset protection structure, and then you have the living trust own the asset protection structure. So instead of having a living trust own your $500,000 brokerage account and 3 pieces of real estate where you can lose everything, you might have each piece of real estate in 3 different LLCs. You might have those 3 LLCs owned by a limited partnership. Your limited partnership might own your $500,000 brokerage account, and then your revocable living trust can own the limited partnership. So it'll end up owning all the assets indirectly, which gives you the best of both worlds. It gives you all the asset protection while you're alive and all the estate planning when you die. But if you simply have an estate plan and everything titled to your revocable trust, you're in trouble.
Thank you. This one is someone that's getting conflicting information or heard conflicting information. They say that sometimes they've heard that it's best to start an LLC within the state that you do business, and in other cases they hear that there are specific states that offer different levels of protection, and it's worth using those states' LLC laws.
Absolutely. So there's 5 or 10 or 15 different states, and you hear about them, Delaware, Wyoming, Nevada, Alaska, blah, 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 that have really made a commitment to asset protection. And they actually fight with each other each year who can have the better laws, because whoever has the better laws gets the more company registrations. But the answer is not just a black and white answer, and let me explain. If you have an operating business where you're truly operating in the state, so you have a physical office, employees, etc., you always want to use the LLC of the state that you're operating in. And the reason is because even if you pick one of those quote-unquote good asset protection states, you're still going to need to register that LLC in the state where you're doing business. So now you're paying double the fees and you're still subject to your state laws. So if it's an operating company where you're truly operating in the state, you got to just create the LLC where you're operating. Now, if you have more of an online business where you don't really operate in one specific state, well, then you can choose, okay, you'll pick and choose. Do I want Wyoming? Do I want Nevada? Do I want Delaware? You can cherry pick and jurisdiction shop because you're not technically doing business in one state. And in regards to the regular assets, like machinery, equipment, intellectual property, to protect brokerage accounts, with those types of assets, you can normally cherry pick the good asset protection states because you're not doing business. You're just holding assets. But if you're truly doing business in a state, you're better off just using that state's LLC, because otherwise you're going to end up with double the fees and you're going to be subject to their laws as well.
Terrific. Okay, do you have any specific strategies for companies that were started using retirement funds?
Can you repeat that? I'm sorry?
Do you have any specific strategies for companies that were started using retirement funds?
Well, it's going to depend. I mean, if you're operating a business out of the retirement account, like a lot of times we'll see people buy properties within the retirement account. Well, you would never want to do it directly. So a retirement account should never own a business. A retirement account should never own a piece of property, because if the business gets sued, someone could take the whole retirement account. If someone gets injured on the real estate, they could take the whole retirement account. So if I'm understanding the question correctly, the best thing to do is, if you're operating assets through a retirement account, have the retirement account create a protective entity. So instead of buying the real estate through the retirement account, where it could cause liability to all the other retirement assets, have the retirement account set up an LLC that owns the real estate. Have the retirement account set up an LLC that owns the business, if that makes sense.
Got it. Okay. Now, here's a question that I've heard frequently out there as well. What's your advice for balancing the risk versus the cost of putting asset protection in place? For instance, franchise and excise taxes, filing fees, tax and bookkeeping complexity, etc.
Yeah, it's a really good question. You know, that's all asset protection is. It's a cost-benefit analysis. You know, we want our clients to spend as little as possible. We want the people going after them to have to spend as much as possible. So if our clients spend 10 or 15 or 20,000 or 40,000 or 50,000 or whatever they choose to spend, we want the other side to have to spend 500,000 or 5 million. So it's really a war of attrition. You want the client, the potential debtor, to spend as little as possible, and you want the creditor, or the potential creditor, to spend as much as possible. We want to make it so difficult, so expensive, if not impossible, for anybody to collect against you that they don't want to sue you in the first place. You don't want to be the low-hanging fruit. So there's no black or white test, because I meet people all the time who they say, look, well, let's spend $5,000, $10,000, whatever it is, and look, we'll get them as protected as we can for whatever their budget is. And then we have big organizations, and they say, I don't care, let's spend $50,000, $100,000, $200,000. I do not want anyone taking what I've worked so hard for. So the real answer of the cost-benefit analysis really lies with the client. It's how well do they want to sleep at night? You know, if they have 18 different properties, do they want 18 LLCs? Or do they want 3 LLCs and stick 6 properties in each one? You know, if they have an operating business, do they want 10 different divisions, or do they want 3 different divisions? So there's really no black or white answer. That's the whole point with asset protection. It's a cost-benefit analysis. But what I tell my clients is that anything's better than nothing. So if you can do 1 extra division or location LLC, that's better. You don't need to do 5 or 10 or 15. Just do 1 extra. You know, if you can have 1 extra LLC to protect your real estate or some sort of asset, it's better than nothing. So at the end of the day, I think the client needs to say to himself, you know, how risky of a business am I in? What's the likelihood I'm going to get sued? You know, we see a lot of lawsuits when people sell their business. You know, they sell their business, probably the biggest lawsuit you see with Vistage members, and 3 years later, the new owner runs the business to the ground because nobody operates it like you, and income goes down and expenses go up. They turn around and they sue the original owner for fraud. I call it renegotiation. So, you know, the minute a client sells a business, you want to put a plan in place. You want to take your chips off the table. But the answer is, you know, you can work within any budget, and you don't have to do everything at once. You know, maybe you say, hey, I'm sitting on a bunch of liquid assets. Okay, protect those today. And then maybe 6 months later, you protect the real estate. And 6 months later, you protect the business. So the answer is, you need to do what's comfortable for you. You can do as little or as much as you want, and you can do things as quick or as slow as you want.
Excellent advice, and something that we hear a lot about when people are selling their business. They become a pretty big target. Now, one other question, and that is, can you comment on ERISA protection in, for instance, assets that are in a 401k? I guess this is someone who has a large 401k, and they're contemplating rolling over to an IRA, but they've heard they have better protection inside the 401k than in an IRA account.
Yeah, and again, there's no black and white general answer. I mean, I guess I could say in general, yeah, if it's a qualified plan, normally you're going to have some better protections because, you could be judged by federal law versus state law. But really, really important, the person, should go to the website. It's at the bottom, assetprotectionattorneys.com, and hit the financial planning exemption button and click on their state and see if the retirement accounts are protected in their state. If retirement accounts are already protected in their state, like Florida, then they can have a SEP or a Roth, an IRA. It doesn't really matter. If the retirement accounts are not protected in their state, then we might need to look at federal law and see what's protected federally, which is obviously going to be most likely, a qualified, ERISA type of plan. So again, look, it can't hurt to have that plan, but it may or may not be needed, just depending on what is and is not protected from an exemption standpoint, and every state is different.
Terrific. I want to thank you very much, Hillel Presser, for joining us today and providing some excellent information. It was very, very informational, and we had a lot of great questions. I want to thank our listeners. Thanks, Hillel, for joining us today.
Oh, my pleasure. Thank you so much for having me.
And I want to remind you, upcoming Fridays with Vistage webinars, Friday, July 14th, you'll hear Building Resilience by Maximizing Your Energy with Dr. Andrea Sycon and from the Cleveland Clinic. And on Friday, July 21st, 2017, Happiness is Not the Key to Employee Productivity with Nikki Llewellyn. I want to thank you again for joining us today. An excellent presentation by Hillel Presser. Please visit his website. And on behalf of Vistage Worldwide, this is Bill Black wishing you continued success.